Well, friends, in the Abrego Garcia case, Donald Trump and Pam Bondi's Department of Justice just went down in flames, with a federal magistrate judge rejecting their efforts to have Abrego Garcia jailed pending trial in his criminal case in Tennessee. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, Donald Trump and Pam Bondi's Department of Justice and their DOJ lawyers are not just losing regularly in federal court, they're being embarrassed. They are suffering stinging rebukes from federal judges in case after case after case. The latest example? The Abrego Garcia case. Here's the new reporting from Politico. Headline: Magistrate Judge rejects Trump administration bid to jail Kilmar Abrego Garcia ahead of trial. And that article begins, Kilmar Abrego Garcia, the Salvadoran man whose illegal and unconstitutional deportation became a high-profile symbol of President Donald Trump's aggressive immigration enforcement policies, may not be held in jail pending trial. On immigration smuggling charges he was abruptly returned to the U.S. to face earlier this month, a federal magistrate judge ruled Sunday. Despite the decision by Nashville-based U.S. Magistrate Judge Barbara Holmes, Abrego is unlikely to be released anytime soon. The Justice Department immediately filed an appeal, and there is an order to keep him, Abrego Garcia, in immigration custody, at least in the near term. Still, the ruling is a blow to the nascent criminal case, which alleges Abrego regularly drove undocumented immigrants across the U.S. for years as part of an international human smuggling ring. Magistrate Judge Holmes said prosecutors failed to produce enough plausible evidence that Abrego posed a danger to the community, was likely to flee, or that he victimized minors while he allegedly transported immigrants across the country. And she, the magistrate judge, repeatedly described the evidence presented by prosecutors as strained, unreliable, and contradictory. While Trump has insisted that Abrego is a member of the violent MS-13 gang, Holmes said the proof prosecutors presented of his gang ties during a day-long court hearing in Nashville earlier this month didn't amount to much. This quote from the magistrate judge, quote, "Given the volume of resources committed to the government's, DOJ's, investigation of Abrego since April 2025, the court supposes that if timely, more specific, concrete evidence exists of Abrego's alleged MS-13 gang membership or a consistent pattern of international conduct designed to threaten or intimidate specific individuals, the government, the DOJ, would have offered that evidence," the judge wrote. Holmes also noted that, while MS-13 has been tied by the government to violent crimes and a variety of other offenses, quote, "Abrego has no reported criminal history of any kind." In fact, Holmes said, the contention that Abrego was in the gang at all was built on double hearsay that was, at times, inconsistent. Holmes repeatedly noted that the government's case, DOJ's case, for detaining Abrego pending trial was built upon multiple layers of hearsay that sometimes defy common sense and were often drawn from statements of cooperating witnesses with extensive criminal history who are seeking favors from federal prosecutors. Okay, friends, there's a lot to unpack in this new legal development in the Abrego Garcia case. So first, we're going to take sort of a close-up look at what went on in this detention hearing and the order that was just handed down by the magistrate judge. And then we're going to pull back to the sort of 30,000-foot view and talk about what we continue to learn about Pam Bondi's Department of Justice and how she continues to delegitimize DOJ regarding the positions that she is requiring the DOJ lawyers to take in these cases. And essentially, those positions they are sent in on, what are largely suicide missions, figuratively speaking. They're being required, if not forced, to try to support the unsupportable. Go in and tell these federal judges that, what Donald Trump's doing, which seems lawless and unconstitutional, is not really lawless and unconstitutional. AG Bondi is doing the exact opposite of what she would be doing if she remained loyal to her oath to the Constitution rather than loyal to a criminal president. If she actually took seriously her responsibility to represent the interests of the American people instead of representing the interests of a revenge-fueled, aspiring dictator in the Oval Office. But let's start with some of the basics. You heard in the reporting the judge was referred to as a magistrate judge, a federal magistrate judge. And a magistrate judge is different than a run-of-the-mill federal judge. How so? Well, federal court judges, as you know, are appointed by the President of the United States. They are confirmed by the Senate. However, magistrate judges, with no disrespect intended here by the way I'm going to describe them, are sort of lower-level judges who typically just do preliminary matters, things like arraignments and detention hearings and preliminary hearings. And then the case gets transferred to a full federal court judge to, litigate the case, handle motions hearings and trials and sentencings. And magistrate judges are not appointed by the president. They're actually selected by the federal judges in that district. So they handle lower level or preliminary matters. And that is what Magistrate Judge Barbara Holmes just did by being the judge who rendered this opinion on DOJ's request to detain, to jail Abrego Garcia pending his criminal trial down in Tennessee. And friends, let's do a quick review of the backstory regarding how Abrego Garcia came to be criminally charged in federal court in Tennessee. You will undoubtedly remember that Trump's ICE agents unconstitutionally snatched up and deported a bunch of folks to El Salvador, violating their constitutional right to due process, notice, and opportunity to be heard in court before they are deported. And federal judges, including Supreme Court justices, wouldn't stand for it. And they directed that the federal government, the Trump administration, facilitate the release from that El Salvadoran prison and the return to the United States of Abrego Garcia. So what did DOJ do? They indicted Abrego Garcia on some trumped-up charges, paper-thin, I would call them bullshit charges. That was my take when I read the indictment in Tennessee in the Abrego Garcia case. I think I predicted as soon as I read that indictment, this case will fall apart, and we're seeing that now in real time at the detention hearing. So basically, here's what they did. They said, well, we're not going to bring Abrego Garcia back from El Salvador because you, federal judges and Supreme Court justices, told us to. No, we're going to do it because we want to, because we just criminally indicted him on some trumped-up charges in Tennessee based on a traffic stop in Tennessee in 2022 in which nobody, including Abrego Garcia, was arrested because there was little to no evidence that he was involved in criminal activity at the moment. They didn't even give him a traffic ticket. It's kind of like, if you tell your child to go to bed at 9 p.m. and your child says, I'm not going to do that, but then goes to bed at 9 p.m. and says, well, it's because I was tired, not because you told me to. That's what the Trump administration just pulled when they brought Abrego Garcia back from El Salvador. And then they asked the judge in that case in Tennessee to jail Abrego Garcia pending trial. And that is what produced this 51-page order from Magistrate Judge Barbara Holmes denying DOJ's request to jail Abrego Garcia pending trial. Let me say a little something about a 51-page order on a detention matter. That's unusual. Usually, and I conducted hundreds of detention hearings as a career prosecutor, not so many in federal court, though some in federal court, mainly in the Superior Court for the District of Columbia, because you may have heard me say in earlier videos that as the federal prosecutors in Washington, D.C., we both did all the federal cases, like this one in Tennessee, but unlike this one in Tennessee, because I never would have brought a case like this, because it's not a righteous case on the evidence based on what we know. But we also were the local prosecutors for the District of Columbia, like district attorneys for any other jurisdiction. But because D.C. is not a state, they don't have district attorneys or Commonwealth's attorneys or states' attorneys. So we, the federal prosecutors, do it all. But ordinarily, friends, a judge's ruling in a detention hearing typically goes something like, okay, I have heard the arguments from both parties, the prosecution and the defense. I've reviewed the evidence, the documents you've submitted, the testimony you introduced during the detention hearing, and I find that the defendant is a flight risk and or a danger to the community, and therefore I am ordering the defendant detained pending trial or pending further proceedings in this case. Or the judge says, I find the government has failed to prove the defendant is a flight risk or a danger to the community, so I will set conditions for the release of the defendant pending further proceedings in this case, and written order to follow. And that written order will maybe review some of the evidence and say basically what I just said, what the judge would say orally at the conclusion of the detention hearing. And maybe the judge's written order will be 2, 3, 4, 5 pages. Not 51 pages. But you want some really good reading, you want to get some justice goosebumps, you want to feel good about what the federal judiciary is doing to hold the Department of Justice's feet to the fire, both on the rule of law front and on the Constitution front. I encourage you to give a read to Magistrate Judge Barbara Holmes' 51-page order. It is meticulously reasoned, eminently supported by case law, and it will help restore your faith to the extent you're losing faith in the criminal justice system. So now, friends, let's dig into just a little bit of what Magistrate Judge Barbara Holmes found. And I want to talk about two of her findings. First of all, she found that contrary to what the DOJ lawyers argued to her, DOJ isn't even entitled under the law or the rules of court to have a detention hearing insisting that Abrego Garcia should be jailed pending trial. They couldn't even make out a case where they, DOJ, were entitled to ask that he be detained or to have a hearing on that request to detain him pending trial. That involves lots of sort of dense technical stuff that I'm not going to cover here, but that was her first finding. At DOJ, yeah, you're not even entitled to a hearing on your request that he be detained pending trial. But she made an alternative ruling. She said, but if you are, I am going to survey in great detail the evidence that you presented to me during this extended detention hearing, and I'm going to rule that if he is entitled to a detention hearing, you, DOJ, failed miserably to make your case in favor of detention. So with that, friends, let's turn to just a little bit of what Magistrate Judge Barbara Holmes said in her order. In the case of United States versus Kilmar Armando Abrego Garcia, here's just a little bit of the judge's opening salvo. The foundation of the administration of our criminal law depends on the bedrock of due process. That due process demands that every person charged with a federal crime be afforded a presumption of innocence unless proven guilty beyond a reasonable doubt, and that deprivation of an individual's liberty prior to trial, in other words, to jail somebody prior to trial, can occur only in carefully limited circumstances with all the procedural safeguards afforded by the law, like every person arrested on federal criminal charges is entitled to a full and fair determination of whether he must remain in federal custody pending trial. The court will give Abrego the due process that he is guaranteed. As required by the Bail Reform Act, the court has reviewed the evidence presented at the June 13 hearing and considered the parties' arguments and the pretrial services report. For the reasons detailed below, the government's motion for detention is denied. And Magistrate Judge Holmes goes on to write, the court finds that the government, DOJ, failed to demonstrate that this is a case in which a detention hearing is authorized. Even if, however, the government was entitled to a detention hearing, the court would still conclude that the government has not met its burden under the applicable law to detain Abrego pending trial, because the court finds that there are conditions of release that can be imposed to reasonably assure the safety of others and the community, and to reasonably assure Abrego's appearance as required. And friends, let me just set up this next passage that I'm going to read from the magistrate judge's order, because she points out that some of this evidence, air quotes around the word evidence, that DOJ presented during the detention hearing involved things like double and sometimes triple hearsay. What's triple hearsay? Somebody told me that somebody told them that somebody said, Abrego Garcia has done some bad stuff. That's an example. And some of the people at the beginning of that triple hearsay chain who first allegedly made these statements were cooperating witnesses who were deported 3, 4, or 5 times previously and were serving sentences as convicted felons. And those people, DOJ and ICE agents, the executive branch, Trump's administration, lavished all sorts of benefits on them. Like, we'll get you out of prison from the prison term that you're serving for your felony convictions. We'll delay your 6th deportation if you say Abrego Garcia did some cruddy stuff. That's hypothetically speaking. But now that I've put a little bit of meat on the bones, listen to what the magistrate judge said about some of that evidence. The first cooperating witness, who provided interview statements and grand jury testimony, has 2 prior felony convictions, has previously been deported 5 times, and was released early from a 30-month federal prison sentence for human smuggling as part of his cooperation in this case, cooperating against Abrego Garcia. He is the purported domestic leader of the human smuggling organization in which Abrego is accused of participating. He has been granted deferred action on deportation in exchange for his testimony. Friends, think about that. The Trump administration and Pam Bondi's Department of Justice takes somebody who seems extraordinarily dangerous, serving a 30-month sentence, a human smuggler, a convicted felon who's been deported several times over. When that person says something that they think they can use against Abrego Garcia, who has no criminal history whatsoever, Abrego Garcia, they lavish all kinds of benefits on him, and they spring him back into the community to perhaps victimize the American people anew. That's the kind of evidence they're relying on to try to get after Abrego Garcia? The judge has a little bit more to say about that. The court gives little weight to this hearsay testimony, double hearsay, through Special Agent Joseph's testimony of the first male cooperator. I should note here that the cooperating witnesses are not named, so the judge will refer to them in this order as the first male cooperator, the second male cooperator, the first female cooperator. And the judge says that she's giving little weight to the double hearsay testimony of the first male cooperator, a two-time previously deported felon and acknowledged ringleader of a human smuggling operation, who has now obtained for himself an early release from federal prison and delay of his sixth deportation by providing information to the government, to the DOJ. Even without discounting the weight of the testimony of the first and second male cooperators for the multiple layers of hearsay, their testimony and statements defy common sense. Now, friends, I want to stop there, but there is a whole lot more in this 51-page order. For example, the magistrate judge finds that Abrego Garcia is not a flight risk. There's no indication that he won't return to court if he is released. But the reason I want to stop there is because we just heard a phrase from the magistrate judge that some of the evidence being presented by the Department of Justice defies logic. That's right. What Pam Bondi is sending the DOJ lawyers into court to do is present arguments and evidence that defy logic. Pam Bondi is delegitimizing the Department of Justice. But friends, let's finish with this. Because even though the magistrate judge denied DOJ's request to jail Abrego Garcia pending trial in his criminal case in Tennessee, there's a good bit of discussion in the judge's order that Abrego Garcia may end up being detained anyway, not in his criminal case in Tennessee, but in his deportation case, which is separate from the criminal case. And the DOJ lawyers basically tell the judge, well, Judge, this is an academic discussion because we, the federal government, intend to try to detain him anyway in his deportation case, to which the judge says, I don't care. I'm paraphrasing. I don't care. I am sawing the legal wood in front of me. In this case, the criminal case where you're trying to detain him, you failed to prove that he should be detained. And that is what I am empowered to rule on. I'm not involved in his deportation case. That's for an immigration court judge. And fair enough. So we'll see what happens because, as we mentioned at the beginning of this video, they've already appealed the magistrate judge's decision to a full federal court judge. We'll see what happens there. But then we're going to shift over to Abrego Garcia's deportation matter. And DOJ is going to say, oh, we want him detained in that matter as well. But here's the thing, friends, and he may be detained, but here's the thing, and here's the argument that I think Abrego Garcia's lawyers will make in the deportation case. They will probably say, Judge, before our client, Abrego Garcia, was unconstitutionally snatched up and, in violation of his due process rights, deported to El Salvador, a place where a judge had previously ordered the federal government, the Trump administration, not to deport him to El Salvador, where was our client? He was out in the community. He wasn't locked up. He wasn't jailed pending further deportation proceedings. No, he was out working, providing for his family. So there is no principled argument that Abrego Garcia should not be restored to that same status before the Trump administration, the federal government, the executive branch, acted against him unlawfully and unconstitutionally. Now, friends, maybe that will fly in immigration court. Maybe it won't. But I think it's more than just a straight-faced argument. It's an argument that does honor to the rule of law and the Constitution, specifically Abrego Garcia's constitutional due process rights of notice and opportunity to be heard. because justice matters. Friends, as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.